Brent. Brent Allan Winters, commonlawyer.com, www.commonlawyer.com. And I'm here with Montana Dan, the other elder. There's myself and Montana Dan, the other elder at In Church. And we like to talk about the laws of nature and the laws of nature's God. The laws of nature, of course, that's our common law tradition, a significant slice of the laws of nature. And the laws of nature's God are Bible. That's what those two phrases from our Declaration of 76 means. I say that on the authority of a man that wrote, a well-known man that wrote, 11 years before our Declaration of 76, William Blackstone, his 4 volumes called the 4 volumes on the laws of England, sometimes called the commentaries on the common law. It is that too, but that's not strictly the official title. But he makes the point that the laws of nature are lex non scripta. Fancy words, that means law unwritten. That's our common law tradition. Due process, law of the land, different names have been attached to it. But then there is that law written, that lex scripta. He said revealed religion, he also calls it, the Bible itself. Religion, our response back to our final arbiter of right and wrong, God himself. Well, let's talk about our common law a little bit. That's the plan here, and I want to talk a little bit, Dan, about nationwide injunctions, nationwide decrees from federal courts. A federal district judge, that's the trial court level in our common law tradition. Is that lawful? Have you heard about this, Dan, of what these federal courts are doing, trying to stop the Trump administration from deporting criminals and people that have snuck in without doing it the lawful way?
Yes, it's appalling, and I'm very happy to hear you're going to chat about this.
Oh, good. Well, what these federal judges are doing is they get a case before them about some particular person that they're deporting, and then they issue a nationwide injunction to stop all importation of anybody like that person. Now that's simplifying it, but they're issuing an injunction against the President of the United States. Remember, in common law government, there are 3 separate and co-equal branches of government. The legislative branch at our national level, that's the Congress of the United States. The executive branch in our common law national government, which is a constitutional government. Our Constitution is a brief of common law government. The executive branch, which is the executor of the laws of the United States, the protector of the laws of the United States, or the man that has the power to do that, to even call out the militia of the several states or any part thereof, to enforce right against other countries, etc. Commander-in-chief he is of the armed forces of the United States. But then you have the courts, the Supreme Court of the United States. The Congress our Constitution of the United States, which is a brief common law government, establishes directly the 3 branches of co-equal powers. In other words, neither of those 3 branches has authority to commandeer the other branch of government. The Supreme Court of the United States has no authority to commandeer the President of the United States or the Congress. The Congress doesn't have authority in our common law tradition, which is our Constitution of the United States. Congress doesn't have the authority to commandeer the President of the United States or the Supreme Court of the United States. None of those 3 have that. It's a perpetual Mexican standoff. Our Constitution of the United States establishes only the Supreme Court of the United States as a co-equal branch of government with the executive, the president, and the legislative, the Congress. But our Constitution of the United States gives authority to the Congress of the United States directly to then indirectly establish other courts if they want to. Well, they've said we want to, and they have established federal district courts. There's the federal district court, that's the trial court. Then there's the federal appellate courts. Congress established those two. Those are creatures of Congress, the federal district court and the federal appellate court, creations of Congress. And what Congress has power to create, Congress has power to get rid of with a stroke of a pen. And they could do that if they wanted to. They could get rid of all of the federal courts except the Supreme Court of the United States, because the people of the United States, which is the militia of the several states, established the Supreme Court through our Constitution. It's a direct product of our Constitution. So the Congress doesn't have authority to get rid of the Supreme Court, but they do have authority to get rid of all of the courts that they have created, which our Constitution gave them authority to create, namely all the federal district courts and all the federal appellate courts. And the question has arisen. DJ Trump puts out some order as a member of the executive branch of government. He's not a member. He is in charge of the executive branch of government. He puts out an executive order, which is what executive officers do, to the immigration bureaucracy, and says, don't let any more of these people in the country, and these people that are in the country, they're illegally, I want them deported. That's within his authority to do. But then some of these people he says he wants deported, they've gotten lawyers and gone into court and challenged his order at the district court level, the federal district court.
Isn't that one of the primary functions of our federal government, to protect our land from invasion?
Absolutely. Yeah. And even the states have that authority under the Constitution if they don't have time to appeal and if the invasion and the threat of invasion is imminent. Texas, for example, has authority under the Constitution of the United States in case of imminent invasion or invasion itself to act on its own to try to stop it. No question. And any other state has the same authority. The governor of Missouri not long ago sent Missouri National Guard troops down to the border of Texas to try to stop the invasion that was coming into Texas because it was filtering into Missouri. And they were bringing, of course, that the new designer drug, fentanyl, and people in Missouri were dying. So he said, I'm going to stop it. I have authority as governor, as executive authority of this state, the enforcer of the laws to defend the borders of my state against foreign invasion. Texas, all the states have that. Of course, it's most pronounced down there along the Mexican border, those states, Texas, New Mexico, Arizona, and California. But yeah, they have that power. Well, the federal district courts, these cases are coming up before the court. There'll be one fellow or a group of fellows that put a case in and say, you can't deport us. And we want the president of the United States to send his lawyers in here and prove why he has lawful authority to do this. And judges, of course, they are Democrat judges appointed by left-wing wackos, and these judges themselves have proven themselves to be that way, lawless. They have said, not only am I issuing an order to the President of the United States to stop him from deporting you, I'm issuing an order nationwide stopping all deportations. Now, I'm giving an example that is more far-reaching than what's happened, but it's pretty far-reaching, just so you get the picture. The federal courts are saying, not only am I giving an order that will stop the deportation of these parties before the court, but my order is nationwide, and it applies to other people like them who are not before the court. Is that lawful? And the answer is not only no, I won't say it. It's not nice, but absolutely not. Never has been. No injunction has issued from a Supreme Court like that in the history of our nation until 1963. Until 1963. And there have been a few then since then. Most all of those kind of nationwide injunctions issued by federal courts have only been issued, most all of them have been issued during President Trump's last administration and now, something like 80. The courts have authority to do that, and the common law rule is absolutely not. The rule we followed in our nation, in our state courts. State courts don't have authority to issue injunctions that are statewide within their sovereign jurisdiction, statewide, to stop everything that's going on that's like what's the parties before the court. Dan, for example, this struck home to me because I one time went into court, and I can't remember how I found this out. I didn't learn it in law school. But there were a couple of fellows that were trying to evade paying rent to my client. And my client had a little house there, and some out-of-towners were living in it, and they wouldn't pay rent. And so I went into court, and there's a certain procedure you follow. Oh, these fellows wouldn't submit themselves to the procedure of the court. And so I asked the judge, will you issue an order, a statewide order, that if these fellows are found or known about, that they would be arrested and bring them into court? And the judge said, well, I want to talk to these fellows too. I want to talk to them, so I'm going to have an order issued statewide within the territorial boundaries of his sovereign state. And if these fellows are found, I want them to come in here. I don't want them throw them in jail. I want to talk to them. It was called a body attachment. It's a non-criminal arrest, a body attachment. Did they have authority to do that? Yes, statewide. But that judge didn't have authority to do that and apply it to anybody he wants. He can only apply an injunction or an order to arrest somebody to the parties before the court over which he has jurisdiction. These federal courts only have jurisdiction with the exception of class actions, things like that. We're not talking about that. We're talking about the courts in our common law country, federal and state, have jurisdiction over the parties that are before the court and nobody else to issue injunctions and decrees. They have in personam, that's personal jurisdiction over them to get what they want out of them, but nobody else. The jurisdiction of courts, even in our Constitution, it says that, number one, it has to be a real case in controversy. There has to be a real, concrete disagreement about how the law applies between two or more parties. Or our federal courts, and our state courts too, won't even hear the case. Get out of here. We're not here to answer hypothetical questions. You guys got a real fight going over the law, and it's real, R-E-A-L? Okay, we'll let you in. That's why our Constitution says the federal courts, the federal district courts, or the federal courts have jurisdiction over real cases and controversies, not hypothetical questions. Number two, the other requirement to get into a federal court, or for a court to have jurisdiction over somebody, is for them to have personal jurisdiction over the parties that have this real case in controversy. This genuine fight over life, liberty, property, or a combination thereof. And if they're in a real fight over life, liberty, property, or a combination thereof, there is no real case in controversy. Well, why do we have that standard? Because our common law courts don't want people in court that aren't really standing to lose life, liberty, property, or a combination thereof. Because if they aren't really standing to lose anything, they're not willing to fight that hard. Our common law is an adversarial tradition. People that come into the courts, if they're not willing to fight over some serious stuff, the courts don't want them. It's not going to sharpen the issues. We're not going to find out the truth if they're not willing to fight. We believe in our common law country, there has to be a fight in order for the truth to even bob forth, like it says in Romans 1. We bury the truth in unrighteousness. How do you unbury it? Well, you start fighting and scrapping and rolling around in the mud, and maybe it'll pop out. That's really what we're all about in our common law country. But no federal district judge has authority over parties that aren't before the court. I was in a court case one time in California, Montana, Dan. and a fella comes up off the street. I knew who he was. He had nothing to do with the case, and he files an affidavit in the case. And we immediately moved to strike it from the record because he's not a party to this case. He hadn't got a dog in this fight. He didn't stand to lose life, liberty, property, or a combination thereof. Get out of here. Well, California being the wacko state that it is, they didn't strike it. That's the kind of judges we've got on the benches. They don't understand the fundamentals of our common law tradition. They won't even talk about it. That's what these judges are doing. They're issuing orders that affect people personally that are not before the court all over the country. That has never been the law in America. It isn't the law now, and they should be dismissed from the bench for even saying such things. They should be impeached. Congress should impeach them. Why Congress isn't moving, I don't know on that point. Well, that's what I see in it, Dan, for what it's worth. And what I want from you is if there's something I left out, please tell me. This is very important.
Yeah. As soon as this gets up to the high court, it will be quickly dismissed, right?
I don't know that.
It should.
No, it should. You know, the law should be followed, but it isn't.
Yeah.
We have renegade judges on the Supreme Court of the United States now, it appears. You never know which way they're going to bolt. Never forget that men at their best, this is Bishop Ryle. He who never quotes is never quoted. I'm quoting Bishop Ryle. Men at their best are still only men at best, and that ain't saying much. And I don't care how educated you are and what Ivy League law school you went to, that just makes it worse. I mean, people talking about these Supreme Court justices are about got to be from an Ivy League law school to be considered. Well, that was never the law or the practice in America either. But now, to make matters worse, the Ivy League schools are not worth much anymore, and they're not even at the top of the heap anymore. Harvard Law School has dropped from consistently being number one or number two in all of the surveys that have been taken. They've already dropped to number 5.
This will probably make it keep going down too, won't it?
Yes, Cornell's dropped down to 15 out of about 170 160, 70 law schools. Well, there's a reason for that. The quality of education is pretty trashy, real trashy. They're not teaching them anything, and what they're doing is trying to fill their ranks with people from other countries and minorities that haven't proven that they're able to handle all that. It's not that they're not smart, it's just that there's discipline that's involved in doing those kind of things. Stanford had the same problem. Big law school on the level with the Ivy League schools. They dropped way down. They said, wait a minute, we got to change all this. We're losing our status. And they did, and within a few years, they started coming back up, but they were letting people in from other countries. That's what they were trying to do. It didn't work. And the quality, people don't understand the law. They don't know the law. The common law courses have been dismissed from Harvard. In the year 2006, they did away with the fundamental common law courses, contracts, torts, for example, constitutional law. Isn't that amazing? I don't know if other law schools have followed that, but Harvard has always been the bellwether until very recently of what other law schools would do. There's not a law school in the country, pretty near, doesn't have Harvard graduates on its faculty. Harvard won't let anybody else teach there but Harvard graduates, you see, pretty much. And most law schools have Harvard professors along with their own. Harvard's been very influential for the entire history of our country. It started, of course, the university was founded by a Puritan preacher named John Harvard for the purpose of, donated his library, and that's how it started, for the purpose of producing preachers. They're far afield from that now, of course. Well, Dan, that's what I understand about it for what it's worth, but if there are other things that come to your mind that you think are unclear, please tell me. And this lisping, stammering tongue of mine, I'll try to bring this home somehow. This is important. It's the laws of nature. That's what we're dealing with here. What is fair? What is right? And how is our government how, H-O-W, is the relationship between our courts and the executive and legislative branch in our common law country is supposed to operate. Our Constitution of the United States lays that out. It's all about how. It's all about process. It's not about substantive law. Go ahead, Dan.
Yeah, there's two problems, big problems. Well, more than that. The one underlying thing is the total lack of understanding of how our system of government is supposed to function according to our Constitution, which is the supreme law of the land, it says, in our government. And why isn't our National Congress doing something about this? And how can a judge not read simple English or read the Constitution and understand their limits?
Well,
I don't know if that's a question or not.
Yeah, it is. I just give you personal testimony. Maybe my testimony of things that I've seen and heard with my own eyes and ears may enlighten people some. These judges that are sitting on the bench are the people, or the representative of the kind of people I went to law school with. And I can testify that for all of their straight A's and all of their high scores on tests, many of them have omitted the weightier matters of the law. That's a quote from Jesus Christ. The weightier matters. Well, what's that? Due process. Not to know the end result, but to know how we are to go about administering God's government. And that's what our Constitution of the United States is, being a brief of common law government. It's about how we are to go about administering government. Like, our Constitution of the United States does not apply to me. I'm not employed by government. Doesn't apply to me. Doesn't apply to you. Who does it apply to? It applies to those that are office holders and employees of government, to limit their power and to function according to these processes and procedures. That's what due process is. When our Constitution says that Article 6 is the supreme law of the land, that phrase, law of the land, has a very specific meaning, lifted from Magna Carta, chapter 39, lex terra, law of the land. It means due process. It means the how, not the outcome, not the result, but the how. There's nothing in our Constitution that says, do not do this, do not do that, speaking to us, the militia of the several states. No, it's not speaking to us. It's telling the government, here's how it's done. This is the relationship between the three branches of government, and here's how government is supposed to work. And you're supposed to do it this way, and if you don't, it tells us, for instance, how we're to come about choosing a president of the United States. All the fussing and fighting and weeping and gnashing of teeth and carrying on that went on after the 2020 election was about how. Well, no, we didn't go about how we were to choose our president, how we were to elect him. We didn't do that. It was a travesty. Clearly, Trump won the election, but that's not the real problem. The problem is not I didn't get my man. I didn't get the man I wanted for president. The problem is that we didn't follow the process of election that the Constitution of the United States sets forth. It's about how, not what. Outcome standards. Outcome standards dictate outcome. We're not a country about outcome. We're not like the Jesuit order. The motto of the Jesuit order, like the motto of all the Roman Church, is that the ends justifies the means. The ends justifies the means. Well, if the end, the outcome, justifies how I get there, I can do anything I want because the way I go about doing it doesn't matter. I could rape, rob, kill, torture, and that's part of the Jesuit tradition, by the way, understandably so. That's part of all of the law, the canon civil law, the city tradition of government in all of the world. Almost every country is under some form of the Code of Justinian of the old Roman Empire. But our common law countries do not say the ends justifies the means. In all those countries, torture and inquisition is the fundamental nature of their government. In our common law country, the ends doesn't justify the means. No. The means, the process we follow, how we go about doing things justifies the result, the outcome. And we say at common law, no due process or wanting in due process then our result is not reliable. Let's do it again and do it right. Our Supreme Court kicks cases back and says, wait a minute, no, we're kicking this case back down to the lower court to follow this process. You didn't follow the proper process. You didn't impanel the jury properly. You didn't sequester the jury. The jury had other influences on it besides the evidence of the case. So go back and do it again. It's the process that justifies the result in our common law world. And by the way, it's the process, according to the Bible, that justifies the result too. The result, the judgment, God says, belongs to him, not us. We are to be process-oriented, due process. Matthew 18, that's the whole point there. When the two of you are bound together and you follow this process, whatsoever is bound on earth has already been bound in heaven. You have found the law. You have found the application if you follow the process. Our courts in our common law country do not say this is the law. They say we have found the law. This is the finding of the court. The how is the big thing. That's due process. And that's what our courts, fundamentally, they don't get. They want to be like the rest of the world. I had said a while ago, Harvard did away with the common law courses in 2006. Why? They did it in favor of international law courses and how other countries do things. They want to forget due process. They want to forget how we go about doing things. Listen, how you worship God, just by analogy, how you worship God is the important thing, not are you a good boy or girl and follow all these lists of do's and don'ts. And you're not going to do that anyway. You're too ignorant and weak and immoral, like all of us. But the one thing you can do and always do and never fail doing is show respect to God. The how you approach him through Jesus Christ, that's the only possibility. If you do that right, he will try to teach you the other things. And when I go into court, it's the how I go into court. I don't come into court blowing and going. I come in quietly. Yes, Your Honor, may it please the court. The how I approach the court, how I approach the jury. You don't go in and tell the jury and act like you're the smartest man in the courtroom. A lot of lawyers do that. They won't win the jury over that way. It's how you approach the other fella. How? That's the most important. He won't hear anything else you say unless you come with your hat in your hand with the respect that the Bible commands. The same thing is true. The same thing is true in our courts. God wants us to operate our government and approach his and bring it to fruition, to an outcome according to his plan of process. And our common law tradition is part of that, the laws of nature, unwritten in the nature of creation, and the laws of nature's God written in the Bible give us the outcome standards. Dan?
So, in a perfect world with the law schools perpetuating their own teachers and requiring their own teachers, and how do we get back to what, in a perfect world, how do we get back to what was envisioned by our founding fathers, and more importantly, what God wants with due process?
We have to do, this is beautiful. We have to do what common lawyers of our common law, did in the early centuries after the Norman invasion. William the Conqueror, he said, the common law is in place, but I'm going to appoint Roman priests to all the benches. Well, a Roman priest is nothing more than a lawyer of the canon civil laws of Rome, the Code of Justinian, put to an ecclesiastic purpose. And if there's a problem before the courts, those Roman priests were going to apply those principles from that law. An inquisitorial tradition, not an adversarial tradition like our common law. Well, there were people in England in that time in the 13th and 14th century that said we're losing our common law tradition, and that's what God wants. He wants the common law tradition. He doesn't want us to lose this. What are we going to do? The Roman priest had overtaken the courts. They said, we'll start our own law schools. They won't let us into, Rome controls the universities. They're not going to let us in there. And so they formed and fashioned what they called the Inns of Court. And they said, we're going to out-discipline these Roman priests. So that was a hard task. They were Roman priests are educated men, educated wrongly, wrong-headedly, but very educated, very knowledgeable, a lot of prestige, fancy robes, all that baloney. They said, no, we're going to overcome them, and we're going to be more disciplined. And they started the Inns of Court to reestablish and create men that were qualified to be on the benches of England. It was a hard row to hoe. This is the history of our common law tradition, and there won't be any freedom without it, that lawyers are not required to learn anymore, except in one state, I think comparative law, we call it, where you compare and contrast the law of the land with the law of the city, is only required in the law schools in one state, and that one state where it's required is the only non-common law jurisdiction in America, Louisiana. It's a civil law, Roman civil law jurisdiction, because of the French influence of and the Code Napoleon became, the Code, it wasn't the Code Napoleon, but it was the French Code from France. Their version of the Code of Justinian of the Roman Empire that became the Code of Louisiana and still is. Those principles still govern. That's why the governor is so powerful in Louisiana. But comparative law is required in Louisiana. So it's up to us to don't despise small things. We've started a law school, an Inn of Court. And you can take the law classes right here on the internet. Sheriff Darleaf and I have taught many courses, maybe a dozen. I don't remember how. We're teaching more. And the next course I want to teach, Dan, look on the internet at commonlawyer.com for it, is the comparative law, comparing and contrasting our law of the land, our common law, with the law of the city, as Wycliffe says, evil men's law, canon and civil laws of the Roman Empire. It's an imperial law. It's not us. Our common law is in contradistinction to it. We have to do it. We have to start these things. We have to teach the truth. God help us. That's the way it starts, small, but it makes a big difference. We have the truth. All we have to do is let the truth out. It's a lion. It will overcome all other points of view. And we want to overcome the law of the city. Well, that's my take on it for what it's worth, Dan. That's what I've decided to do with my life, what's left of it. God help me. And that is the remedy that has worked in the past.
So, not all, but some lawyers, attorneys have a pretty smug opinion. How would they take coming to a class like you've already produced?
Forget them. Forget the lawyers, Dan. We must think. I'm a big proponent of the idea that we must think in the long term. That's the way God's kingdom moves forward. He's not in a hurry. 1,000 years is as a day, and a day is 1,000 years. And John Wycliffe wanted to see that was in the 1300s. He's the man that translated the Bible into English for the first time. What's ignored about him is that he had coupled up with his brother-in-law, Geoffrey Chaucer, a well-known literature fame. He was a common lawyer in England, and they said, we got to do two things. We've got to get the laws of nature's God, the Bible, into English so that even the boy behind the plow, walking behind the plow, can read it in English. It had never been done. And we've got to get our common law tradition into the Oxford, the university there, be taught in Oxford. Well, he got the Bible into English for the first time. It was a pretty rough translation, stilted. Just took word for word in the order of the Latin text, by the way, which isn't English order, but it wasn't that he wasn't a smart man. He was very educated, but that was a new idea. Nobody had ever thought of that for over 1,000 years. Let's see, since about 400 AD to about almost 1400 AD, that's 1,000 years. Jerome translated the Latin Vulgate. That's all they had in Europe and England was that Latin translation of the Bible, which most people, of course, couldn't read. So, no, we've got to bring the Bible to everybody. He did that, and Geoffrey Chaucer, his brother-in-law, believed that the Bible, or our common law, ought to be taught in Oxford. But after they did that, and after they started that movement, it didn't happen. It didn't happen for 600 years, not until William Blackstone delivered his lectures at Oxford in the year 1765. was our common law taught in England, and even then it was through the back door, because the man that funded those lectures, a Jewish merchant, wealthy man named Werner, commissioned Blackstone to lecture on the law of the city of Rome, the imperial law, the Code of Justinian, the canon civil laws of Rome. He said, well, the only way I can do that is compare and contrast it with our common law. And so that's what he did in those lectures. And when that happens, of course, the common law always comes out on top as superior. And he didn't hesitate to say that. And that's what those 4 volumes are. They aren't lectures on the common law as much as they were supposed to be lectures on the law of the city. But not until then did that happen at Oxford like Wycliffe wanted 600 years before. 600 years? No, I'm thinking too many. Let's say 1400 to 300, almost 600 years, but yeah. Well, that's what our job is as Christian folk. We're to quietly be that pilot light that never goes out and keep teaching the truth. Christian men and women start things. The evil empire hijacks them. Harvard has been hijacked. Harvard Law School has been hijacked. The whole blasted university has been hijacked. It started way back in the early 1800s when they announced Christianity and turned Unitarian, Harvard did in 1811. So I encourage you to take these law classes. We need a new crop, Dan. It's our job to not let the truth die. We need a new crop of lawyers. And we want to draw them to the law school that teaches about our common law as being superior.
Is there anywhere else they can get this stuff without digging into some of the old manuscripts, the old, like Blackstone or?
Oh, well, of course, yeah, I see what you're saying. Of course, going to the law school, we try to teach those things, the fundamentals of our common law tradition. But the next course we're teaching, Lord willing, is comparing and contrasting the law of the land, our common law tradition, with the law of the city, the Roman canon civil law tradition. And if in doing that, I'll want to use the book, and I will use the book called Excellence of the Common Law, a 957-page book comparing and contrasting the law of the land and the law of the city. And you can procure that book, of course, at commonlawyer.com, and written by yours truly, Brent Winters, 957 pages. It's hard to find a lawyer that is as interested in this as I am. Every lawyer in America is a common law lawyer to some degree. Have to be, even in Louisiana, because of the federal law that overlays our system from our Constitution of the United States, which they must swear to as well. But we'll read through sections of that book. We won't be able to cover it all. But it's hard to find a lawyer. I found some. Found one fellow from Suffolk University that's a proponent of our common law. And what really encouraged me, and this has been 15 years ago at least, maybe more. Oh yeah, more. 20 years ago. He said to me, I keep that book by my nightstand. Professor of law, I keep that book by my nightstand, he said, because I'm just so encouraged that another lawyer wrote a book about it, because I've been promoting these ideas, and he'd written books and articles as well. And I said, well, maybe there's something here. And a book like that hadn't been written since Sir John Fortescue in the 14th century, like the book Excellence of the Common Law. He wrote a book called In Praise of the Laws of England. That was an important book at that time. Well, try to boil it down to the bottom line. Our common law tradition is for us. It's not for the scholar. It's about fact, not scholasticism. It's about fact, not logic. No. I talked to a fellow yesterday, Dan. I'm trying to persuade him, and I said, well, I know a lot of things that aren't logical and I can't explain, but I know are true and everybody accepts as true, but we can't explain them. There are a lot of things like that in our world, and fact is more important than logic. Well, if you don't start with the right fact, your logic's going to be off anyway. Well, Dan, I think I don't want to
we're getting kind of long, but so what age group or what target audience? If somebody's just starting into law school, is it too late?
No.
Homeschool. What venue? What venues?
Well, I've had homeschool parents tell me they read a section out of that common law book. They've read it to some of their children. Some of those children, they told me that, are now graduated from university someplace, and they're doing other things, but they had read that whole book to them, and they liked it. We're talking high school graduates here. Parents read that book to their children. They were homeschooling, and they liked it. Also, I've had some people say, well, I want to take your course. I want to go to law school. You know, there's some Christian law schools out there call themselves Christian, but they don't go down this road. They try to conform. You see, if you try to conform to everything in the evil empire, you're not going to get anywhere. Well, we want our students to pass the bar exam, so we're going to teach what they want us to teach. Well, you can do that, but you're neglecting what's most important when you do that. And I know Christian law schools that do that. I had one fella, Christian law school, very well-known law school out in California, and he wanted to teach a course using that book, and him and I talked a lot. He was a professor at the Christian law school. And then when he was just getting ready to teach it, and we kind of understood each other, he passed away unexpectedly. He wasn't that old. He was younger than me. He passed away, so that idea died. The devil will do anything to stop people, to stop his truth, his fundamental truth, the laws of nature, from being part of our tradition, because our common law tradition is a Christian tradition that goes back centuries. As Justice Joseph Story of our U.S. Supreme Court said, he said, at the foundation, he's not only the judge in our America that said this, but he said at the foundation of our common law tradition lies Christianity. And he was a biblicist at that point. It does. Our common law tradition is the laws of nature. It is the nexus that puts the rubber of the Bible to the road. The Bible gives us the end results, the outcomes that God wants. Our common law tradition is our jurisdiction, the outworking of being fair and trying to bring those outcome standards to the road. And if we cut that off, which we're doing, and to say that's not important, that it doesn't even matter, our common law is not a list of do's and don'ts. It's not a list of laws. It's a way of life. And if you don't, that's why Jesus Christ said, he didn't say I'm the list of laws. John 14:6, he said, I am the way of life, he's talking about. The way, the road, the path, the process, the progress you get on to live a decent life. That's what our common law tradition is. But yeah, you don't have to be old, young. I follow the idea of the Scottish Enlightenment. You know, they invented adult education in Scotland. They invented the high school during those years of the Scottish Enlightenment. Our product is our country, America, is the product of the Scottish Enlightenment that overtook the whole island of Britain. John Locke, an Englishman, he was the greatest fan of the Scottish Enlightenment. Our Declaration of 76 is the product of the Scottish Enlightenment. And so we want to teach everyone matters. Christianity is not for young people, like politics seems like it's for young people. Christianity is for people that are living this side of being taken from this veil of tears. Young people, old people, I talked about homeschoolers, but we need these old heads too. They're the ones that are steady. You got gray hair, white hair, no hair, whatever kind of hair. You got the signs of old age. Yeah, you're important, very important, because you have under your belt life's experiences. Then you add the truth to it. Then you've really got something. And I know you've probably been adding the truth, but let's add the common law tradition, the nexus, the conduit that makes the outcome standards of the Bible, the Ten Commandments, a reality and experience, and brings joy and productivity to life. Well,
we started off with a big problem we're facing in today's headlines, the out of control courts doing things that they shouldn't, and we ended kind of with a solution that I guess we all need to educate ourselves and be more proactive or better stewards. Is that a fair way to say it?
Yep. Oh, very fair, I think. Yeah, all of us. And no, you old folks or older folks or middle-aged folks, we're all going to be old sooner or later, God willing, if he allows us to live that long. That's when the experience can be coupled with the truth. Don't think you don't have an influence. You do, to your children, your family, your neighbors. And it's just a matter of who we are and how we approach life that's important. Without that, we're omitting the weightier matters of the law, as Jesus Christ put it. Thank you, Dan.
Thank you. We've been going